New dimensions in criminal trials, I would not say carries a new ignite with the coming of the new three acts. But yes, as we all discuss, the trials, or I would say in all jurisprudence, maybe it is in the civil, criminal, or service jurisprudence, or in fact, even in the constitutional jurisprudence, there have been new dimensions. The nature of litigation has changed. I can say that, like with the in the service matters and constitutional matters, with the flux of RTI, the nature has changed. Similarly, in different fields, there are different aspects. And I was connecting with Mr. K. Diwakara, who is the senior advocate from Karnataka High Court. He also expressed, when we were shortlisting the topic, that there are new dimensions and new perspectives, and also as to whether what is the significance in different trials and different perspectives. On that aspect, we connected through Mr. Trikram, who is our knowledge sharing partner, and Mr. Diwakara is also a senior, and he was sharing with me that whatever knowledge or whatever little big steps he has made in his profession through Mr. K. Diwakara. And I was reminded of the Kabir saying that Guru Gobind Dau Khade Kake Lagu Paye Bali Hari Guru. That is to say that if God and Guru are standing simultaneously, the famous Saint Kabir said that you have to first rever the Guru, because it is through whom you get your enlightenment. So that is what Trivakram revers Mr. Diwakara for his knowledge. And once he has been a connecting point for various speakers, I can understand today we will be having knowledge not only of the criminal justice, but other aspects also. Over to you, Trivakram, and then we will request Sir to share his knowledge.
Thank you, Mr. Vikas. This is a great opportunity. Whatever I am today, little bit, it is all because of my senior. So he is one of the most sought criminal lawyers in Bangalore, Karnataka, and even he practices before the Supreme Court. He is a designated senior advocate. With his rich and vast experience, he has nurtured so many juniors, and I am one among those juniors. I am so grateful to him forever and always, and it's a great pleasure, sir, to see you on this forum. We are elated, sir. And on my personal behalf, as well as on behalf of Beyond Law CLC, warm welcome to you, sir. Over to you.
Thank you, Mr. Vikas and Vikram. It's a matter of opportunity to share my little experience with my fellow colleagues in this afternoon. As you are aware, we are confining ourselves to a topic, criminal trial. The most important aspect of criminal jurisprudence in India, the 80% of the criminal jurisprudence, as we have admitted, the punishment provision or administration of justice is the state responsibility. Whenever a charge sheet is filed, it will be filed in the name of the state. Suppose a FIR is filed in the state of Karnataka, it is state of Karnataka versus accused. If CBI files a matter, it is Union of India versus CBI. 75 to 80% of the criminal cases are instituted by the state. So state responsibility means it's a constitutional responsibility of the state to punish the accused. Our administration of criminal justice system is accepted as a state responsibility. When state has taken the responsibility of administration of criminal justice system, punishing the errants is also a responsibility of the state, where the power has been delegated to various agencies. In a normal parlance, this power has been delegated to, in an ordinary meaning, to the state police. And once the police have taken up the investigation, even the question starts with the registration of an FIR. Registration of an FIR ends up in a final report, post-investigation, it will end up in a charge sheet under section 173. Today, I am confining the subject to the old CRPC because the infant new criminal laws have not come into the force, or no trial has taken place anywhere in India, in my information. So BNS or Sakshi Adhinayam, they have not come into practically enforced in the, though they have been notified, we are not enforcing them in any criminal trial. So, out of my experience as a criminal lawyer, I will confine the today's deliberations and discussions to the old law, old CRPC. The first question comes, what is the purpose of the criminal trial? The criminal trial, the purpose of the criminal trial is the quest for justice, where the person who has committed an offense has to be punished, and justice has to be prevailed upon the person who has suffered. That is the purpose of the criminal. The next question starts, whether the criminal trial starts with an FIR or criminal trial starts in a process of a. Today I am confining myself before going to the warrant cases or summons cases. I wanted to concentrate on the sessions trials or sessions criminal trials. The lowest criminal trial as a criminal practitioner has to ensure himself when he plunges into the criminal practicing system, or he wanted to identify as a criminal lawyer, the first and foremost trial he has to start with the 279 of the IPC and 337. That is, which is a gross and negligent driving with a simple injury or a grievous injury. That is up to 304. But the first and foremost trial any criminal lawyer should start at, on my experiences, with section pertaining to 279 and 337 and 338, which have been classified as summons trials and warrant trials with the magistrate. But the most important concept or most important branch of trial is sessions trial. What we call a murder trial, 302 trial, in a common manner. Or in a earlier European colloquial meaning of manslaughter, which had been converted into murder, culpable homicide amounting to the murder, and 302. When the sessions trial starts, prior to now, because of some special legislations, the character of the sessions court has also been converted into that of a magistrate. In an SC/ST case, directly the accused is produced before the sessions court, which is also designated as the magisterial power with a special. Even in NDPS cases, they have been, in some states, they have been produced before the sessions court. Even the new formed legislation, POCSO, the accused are produced before the sessions court. But earlier, even the grievous offense is 302 in the Indian Penal Code. In that case, the session trial starts pre-committal, or under 207, every document or every charge sheet filed under section 173 is furnished to the accused, and case was committed with for the sessions trial. Prior to that, whether this committal proceedings is optional or discretionary before the magistrate is also a question. There is a 209 proceedings. If it appears to magistrate, the ingredients of the final report which have been furnished to the accused person having an offence exclusively triable by court of session, then only it is a fit case for trial before the session. Once the case is committed to the session, then the question comes, here before charge. Before framing the charges, the sessions court has to hear the accused, which is normally called a discharge. A discharge application has to be filed, or alteration of charge. Suppose in an event where a 307 case, attempt to murder case has been filed, it comes to the discretion of the presiding officer of a sessions court. The ingredient of the offense and the post injury certificate and all those necessary ingredients furnished along with the 173 documents having a prima facie offense which comes or which can be sufficed under section 324 or 326 of the IPC, then the sessions court may recommit it back or forward it back to the magistrate for its trial. So the most important thing is whatever police have filed a final report, whatever charge sheet has been filed, it is not going to be a gospel truth before the sessions court. Sessions judge has to ascertain himself whether the prima case has been made out in dictum and diction of a section as explained in the Indian Penal Code. If it is exclusively triable by session, then he will take the judicial notice of it, then discharge application, framing of charges. Framing of charges is the most important component of a criminal trial because sometimes police will fight any number of Indian Penal Code sections in the charge sheet. For example, if there are 3 or 4 members are there who have been implicated in a case, they may invoke section 34 common intention. They may invoke section 120B, that is the conspiracy, or 149 unlawful assembly. All these sections will cement together the accused person. So that aspect, whether all accused have a participatory role or conspiratory role or abetting role, the court has to ascertain the fact there is so many instances where there are 4 or 5 accused persons have been committed for trial and the sessions court has discharged 2, 3 accused persons and conducted the trial only against 1 or 2 persons also. So whatever number of accused have been committed, they need not be accused before the sessions court to face the trial. Hence, these ingredients of the section has to be observed by the sessions trial lawyers when they once the start. Then the trial is going to be fixed. When trial is going to be fixed, as you are aware, in some cases like offense under 376 or POSCO, in-camera proceedings are taking place nowadays, where the identity of the accused has to be protected and all this. So in some cases, in-camera proceedings take place. In other cases, court is open to everybody. Anybody can court in a public place. Anybody can attend the trial. Court is open, but only in-camera proceedings, the trial is restricted to the concerned person, like in POSCO or 376 and all. When the trial starts, before trial, the charge has to be framed by the sessions court. Charge may be framed. The police may file cases for 5 sections, 2 sections, 3 sections, or any number of sections. Even another important aspect you have to notice, if an accused is charged with 7 different sections, only a section may be there which is exclusively triable by sessions. But the other sections, which are otherwise has to be triable by the magistrate, will be ancillary to the section which is triable by the court of session. For example, if any offense is there of some 307, it may be read with some cheating or some purpose 464, 460. All triable by magistrate sections may be also be invoked. Hence, the prime section will be sections exclusively triable by the sessions. Once trial starts, the Before commencing of the trial, the defense counsel has to go through the every statement which has been imbibed in the charge sheet. He has to demark the witnesses into different categories. First is eyewitness account. Second is circumstantial witnesses. Third is Mahajar witnesses. Four is expert witnesses. Fifth is police witnesses. Six may be other witnesses. But in a criminal trial, the most important aspect is the account of the eyewitness. The eyewitness account is called the prime account of any criminal trial. But whether the eyewitness is a true eyewitness or a doctored witness planted by the police to narrate the fact, whether he is a doctored eyewitness or a genuine eyewitness, one has to ascertain the thing. My advice to all criminal trial practitioners who are participating in this seminar, the best thing a criminal advocate has to do is, suppose a murder takes place at 6 p.m. in a usual place in a market area. The trial advocate who conducts the defense has to visit the spot at the given time. Around 6 p.m. he has to go and watch the spot inspection, what we call. Once he makes the spot inspection, he will be aware of the circumstances in which the accused offense has been committed. He should note down the topography. That may help to cross-examine. If suppose there is a wine shop before that alleged spot, if police have not made any mention about it, he may suggest it. If it is denied or if that is, it is going to be a great help in criminal trial. Number two, after eyewitness account, the Mahajar. Mahajar is the most important component because almost whenever Mahajar takes place, whenever some weapon has been used for committing an offense, if that weapon is concealed elsewhere, that will be seized by the police in a Mahajar. Whether the Mahajar report or a Mahajar Panchanama, what we call, according to the criminal rules of practice, it has to be written at the spot itself. But of my experience as a criminal lawyer, in the majority of cases, they visit the spot. Ultimately, they write the Mahajar in the police station. If you are able to make a distinction of this, it will also have a great defense in the criminal trial. The next comes the autopsy report. As you are aware, in a criminal trial, before post-mortem, there is an inquest is that what we call ante-mortem injuries or ante-mortem positioning of the corpus or whatever it is. That inquest, the distinction between the inquest and the post-mortem has to be marked by the defense counsel. That will also, because case by case you have to study the matter. There is no standard parameter to study this case. You have to go case by case alone. In a case, just for an example, I am telling you, in a case, allegation was that a motor vehicle was used to commit the murder through an engineered accident. The great veteran criminal practitioner Subbarao, I am talking of a case of 1996, he cross-examined an expert under 45 of the Evidence Act for 1.5 days. Ultimately, he was able to prove the motor vehicle inspector, who is a competent education under mechanical engineering, was unable to give an opinion regarding the automobile mishap. That means expert is not a competent expert to support the case of prosecution. That was done in a case under 45 Evidence Act, 1.5 days. That was the acumen of great veteran C.V. Subbarao, whose junior C.V. Nagesh is one of the leading criminal lawyers of the country. We have seen those. Hence, my second request to all criminal trial interested advocates, this criminal trial cannot be, or your knowledge of criminal trial cannot be accumulated through curriculum or books. You have to see the practical criminal trial from beginning to end. Whether it's a post-court case, whether it's a murder case, or an attempt to murder case. The practical training in a sessions court wherein experienced lawyers are making cross-examination, that watching alone we will learn the process, that is called criminal practice. The word practice will come into force like that. That is also my. The next comes the recording of the evidence. Of course, many times we come across the statement of the witnesses in the box on oath is different, and dictating the judgment is different, and reading the question is different. In CBI cases, I come across. There, when the recording of evidence is taking place with all alertness, we have to see every word is important. Every word is important. So that recording of evidence is also has to be monitored by the defense counsel. Is my first mistake. Hence, now what happened? What I am telling you is the old school of thought in criminal trial. Now, post development of electronic evidence. Earlier, the opinion of the doctor of post-mortem or autopsy report was final to regarding the injuries, whether that injury is caused by the weapon which has been seized. These are all the factors which we are doing in the criminal trial. Now, even eyewitness account has been substituted by your cameras, your mobile locations. Earlier, last scene circumstance was also a reason. Regarding 302 cases, whenever last scene circumstance was used as a hard evidence in the old system. Now, the telephone connect calls, the call details, cameras, all these things are ocular things have been evidencing or recreating the actual scene. Hence, we have to make out our defense in par with the electronic evidence. Whatever electronic evidence which they are submitting with the 65B, the copies will be furnished to us. The defense lawyers have to watch every fraction of second of the electronic evidences furnished by the police to the court, and the copy which has been given to us, we should watch it with very diligently and very meticulously, then only. In a recent case, the electronic evidence which has been furnished to the court was different, and electronic evidence furnished to the defense counsels were different, and electronic evidence of the prosecution, it was different. Ultimately, as you are aware, the benefit recipient was the accused, and it was ended in a grand acquittal. Hence, the electronic evidence is playing a very important role. And now we have to, even regarding the criminal trial pertaining to the forgery and other aspects, we have to be very cautious regarding the computers which have been used and computer object which have been computer and computer outputs which have been used. I was also an advocate who passed out of law college around 3.5 decades back. At our time also there was no computer or electronic thing. But now the computers are playing a very important role, what we call forensic evidence. The forensic, for all this admissibility of forensic evidence under section 45 of Evidence Act has been elaborately narrated in the Supreme Court judgment of Tiruvella Pillai versus Narasimha, AR 2008 SC 1541, it can be considered as a landmark judgment regarding the admissibility of electronic evidence. That the younger generation has to justify. And even regarding computer, the laptop version, desktop version, their distinction, and copying of the evidence, electronic evidence from one unit to another unit, and even the possible doctoring of the document, all these modern scientific aspect has to be taken into account while questioning the witnesses. Is also my suggestion. And regarding the other aspect, as you are aware, even forensic evidence, though the computer has come into force, the first generation computer of 1937-46 and second generation is of 47 to 62, and the 63 to today's third generation computer has come into. But we should also be aware of the information in the input unit and storage unit and also output unit. What is given an input, what was storage, what was an output. There is at every moment, there is a possibility of doctoring or contaminating the evidence. That aspect also we have to take in the new dimensions of the criminal trial. Regarding ballistics, the most important aspect is where a firearm has been used for conducting an alleged offense. The most important aspect you have to consider is the capacity of the firearm, output cartridge or entry wound in the human body, exit wound, and the speed in which the entry wound of this thing. Always the entry wound is small in nature, exit wound is 10 times bigger than the entry wound. Those distinction you have to keep in mind while conducting the ballistic thing. So before conducting any ballistic related offences in the new criminal trial, you should have a first-hand information pertaining to the weapon used for the commissioning of the offence. When you are doing regarding electronic fraud, we should be aware of the facts about the functioning of the electronic apparatus which has been used for committing those things, whether it is possible or not. The alleged offence is possible or not. With that question we have to. And furthermore, though the principle of criminal law is that accused is innocent till the guilt is proved as a fundamental right to presume accused is innocent. But at least if you are not able to convince the court, the criminal trial defense lawyer should make a thing to create two opinions. One opinion or two versions or two opinions pertaining to that. At least at that time you are defending your accused with a version which is beneficial to you. And sometimes when you feel it is difficult for getting an acquittal, keeping in mind some strong judgments on that point of law, we should we have to put a question in such a form which has been narrated in some judgment which has ended in acquittal in Supreme Court or in our High Court. With that judgment in our hand, we have to put the question, hoping that if the court is not going to acquit him tomorrow in the appeal, we will get an acquittal. That should be a motto of our new jurisdiction. So the new dimension of criminal trial, according to me, is changing circumstances of scientific development. And we have to ensure ourselves with the growing development in the scientific development and their adoption. Their adoption in the even regarding narco analysis. Supreme Court has said the narco analysis is not admissible in evidence. Even then, narco analysis was also considered as one of the strong evidence for some time. Now, the most important aspect is how to overcome the evidence or alibis created by the accused in electronic form, which has been catched by the cameras or phones or in any other fashion and manner. So this is the most important thing we have to consider while making a criminal trial. And another aspect is in the criminal trial, whenever the accused come for deposing before the court, if the examination chief take place on the same day, you have to ascertain two things. Whether this accused is giving the parroted version of the prosecution or he is supporting his own version before the police in the police station. If he is giving a evidence of parroted version of the prosecution, the best option for you is to defer the cross-examination. To defer the cross-examination for the day, and then in the next date of hearing, we have to prepare ourselves the questions in such a manner and fashion, thereby our defense points have been strengthened or amplified. That has to be taken. But the criminal trial, my experience is, it cannot be stated like that ready-made, it's not like a ready-to-eat food. You have to prepare the cushion of your choice, then you have to eat. Preparing a cushion of your choice, it needs lot of efforts and lot of different ingredients. Ready to make food is only passing an order. So hence, whoever interested in criminal trials, my first foremost request is watching the trial or even if you have watched the trial before this magistrate court also, it will add to your experience. Post-committal sessions trial you can watch. If suppose a case is ended in a conviction, appeal argument you can watch. So by watching the proceedings and following a case meticulously, you can in one or two cases will make you a perfect how to go ahead with the new trials and all. And trial is like a swimming. You have to plunge into water and swim. So trial can be learned not by watching. Trial can be learned by actually practicing yourself. It may start with the lowest thing, even a 138 trial, it may be before a magistrate, or a 279 trial, or a minor trial before the SC/ST Prevention of Atrocities Act before the Court of Session. Likewise, the trial. Whoever participating in today's seminar, my request to everybody is, whenever an opportunity comes to conduct a trial, grab it and conduct the trial. You will be the best advocate. And another thing, now our population is 1 crore 40 lakhs and something. Number of criminal cases will definitely increase. New found criminal cases are coming every day. New type of criminal offences are taking place. Hence, there is a lot of opportunity for the criminal trial advocates in days to come. I hope you will grab the opportunity and equip yourself as successful advocate. And every bar in India has got a famous trial lawyer, whether it is Tamil Nadu. In every place there are experienced trial advocates. My only request is those the doyens of bar has to be followed and their case has to be studied meticulously. They'll make it. So new dimension of criminal trial is based on the acumen of the advocates who are interested in it. And of course, the criminal trial starts and ends with a judgment of acquittal or a conviction. Starts with a charge. The criminal trial starts with a charge and ends with an acquittal or conviction. In between, in between that period is an acid test for any criminal lawyer. And the confidence and acquittal gives to an advocate of a criminal advocate, nothing will. If you win a criminal sessions trial, the amount of confidence it will inject in you, no other trophy can give you that certificate. With this submissions, if in outline I have touched the subject, and I will also interact Mr. Chirath and Vikram. I hope basic ingredients of the criminal trial have touched upon.
Yeah, Vikram.
I think we have a couple of questions. Somebody is asking about alternative dispute resolution in criminal law. Sir is muted. Sir is muted.
Just hold on. Yes, sir.
As you are aware, the alternate, the ADR in criminal trial, section 320 of the CRPC, some of the offences can be compounded amongst the complainant and the accused, and some offences can be compounded with the permission of the court. In some offences now, filing a 482 by both the parties from a Supreme Court obiter dicta, they have been compromised before the High Court also, and some have been referred to Lok Adalat. Now plea bargain has been introduced in BNSS like American jurisprudence. Injured has been compensated like that. So alternate dispute ADR in the criminal law in the existing criminal trial will be in the compass of section 321.
Yes, sir. Mr. Varun has sent a message through WhatsApp, sir. He wants to know what are the attributes which are required by a trial court lawyer, especially who is practicing on the criminal front.
First and foremost thing, courage. Courage to face the police. And also, nowadays, from the date of alleged offense till the trial, a criminal, because of this electronic media and other things, almost in every state, criminal cases have been glorified. A public opinion has been created against the accused. Whatever public opinion generated against the accused, without any heed to it, a defense lawyer has to make his base a strong base. And once he stands on a strong base, he should not alter it. The defense of the case has to be fixed by the defense counsel at the threshold, at the beginning. He cannot fluctuate between the defense. Oh, prosecution has asked this question, so my case will end up in acquittal. Those chances should not be taken up. In the beginning, when you start the trial, you make out your defense line very clearly. On these defense lines supported by these accused statements, I can get an acquittal. So defense points are very important, and unfortunately, the tendency in the courts today, prosecution, whether CBI or state police, think the courts are their extension. But in reality, it is contrary. They are also a necessary party like me. They are only complainant advocates. I am a defense lawyer. So the court has to, like an umpire or a referee. So the court atmosphere today, it appears to a new advocate, whether it is an extension of the prosecution. That is not so. Hence, we keep in that mind, with courageously we put our questions. And even sometimes court interrupts. Even whenever the court interrupts also, we have to abide by our stand, and we should pursue the witness till such time when we get a necessary answer which will defend my client.
So Mr. Nagaraj has a question. He says that once the trial is handled by a different advocate, and when he is handling the appeal, could there be a change in the defense? Would that would that make any difference in the during the course of appeal?
Vikram, what happens normally if the case is acquitted, if state prefers an appeal, 90.99.9% whoever in a city like Bangalore, if they are practicing in the High Court, they will engage the same counsel. If it happens in the official area, the choice of the advocate will be whims and fancy of the trial court lawyer with kith and kin he may appoint. Sometimes what happens, if the case is ended in a conviction, it may create a no confidence in your client, he may engage other counsels also. It depends upon the client's mind. And ultimately, no client, what the clients want is an acquittal. It is not the manner, the fashion in which the cross-examination has been done, the argument has been done. The client is prima facie interest of the client is the end result. If you have gotten acquittal, you are a best judge. Number of acquittals will make you a celebrity. Number of conviction will send you to oblivion. That is the order of the day. So we have to be very cautious. The prime goal of every criminal advocate should be getting an acquittal.
So very nicely put across. They say that nothing succeeds like success.
I think Mr. Ganesh has one question last question from my end, sir. His question is the role of the messages or the technology, as you were mentioning, especially he has quoted WhatsApp messages. What is the role of these evidences in criminal trial? And his particular question is restricted to 138 proceedings, but by and large, I would want to expand it throughout the horizon of criminal law.
See, Mr. Vikram, as you are aware, some legislations, recent legislations which have come into force or recent amendments which have come into the force, they have changed the basic dimension of the principle of criminal jurisprudence. When I started my practice, accused is innocent till the guilt is proved. Now, vice versa, accused is guilty, prove your innocence yourself before the court. American jurisprudence. In 138, what is the 138? Unless otherwise proved, issuance of check is for liability. The burden lies upon you to the negative proposition. Once you have issued a check, unless otherwise proved, the very dictum and diction of the section is valid, and section 45 of the Money Laundering Act, accused had to bring before the court that he is innocent, he has not used the proceeds of the crime, 45 of this PMLA Act. Now the new draconian acts have been designed to such a fashion and manner which have got earlier our basic law was influenced by the Anglo-Saxon British doctored laws. Now post-liberalization, our laws are engineered or guided by the American jurisprudence. American jurisprudence is totally contrary. We have not acclimatized ourselves to that type of trial. So that is, and regarding electronics and all other media, instead of substance of electronic things, whether it is a genuine or doctor, whether it is now manipulated, some photos are manipulated, some now people are blackmail with the some picture, doctoring the photos, scenes and all obscene and all those things. Even electronic things also have been subjected to a lot of intellectual corruption. So that aspect, if you demolish that, the very electronic evidence is not believable in nature, you will win the case.
So I think since he's your senior, I thought why not there could be an occasion where you can actually honor him. You have been already honoring him, but honoring him virtually rather than this thing. You would be honoring him actually, but we will see. Why don't you do that?
Yes, thank you for the opportunity. I'll just switch over.
Thank you for the opportunity. We'll meet physically. I am eager to participate in this thing. I thank everybody. I hope for your satisfaction I have participated in this thing.
1 minute.
traditional way of thank you.
That's a great honor for anyone. Vikram,
Thank you for the felicitations also.
the way you spoke, and I could understand why Vikram chose you out of all the lawyers.
Thank you, sir. Thank you, sir. Thank you very much. And it also, you have provided me an all India opportunity to express my this thing. But however, as a criminal trial is a vast branch of law, I think to the satisfaction of the viewers, I have participated. If any deficiencies, my apologies are always there.
It was actually a good session. And tomorrow, with that journey with Vikram and Associates, we come out with next session, important changes brought about by BNSS 2023, and that is by none other than S.R. Somashekar, a former district judge from Bangalore. Do join us tomorrow at 6 p.m. Thank you, everyone.